Well, hey, folks, what a tough week for the true crime community and, frankly, the world. Chad Doerman's accused of executing his three sons. And this morning, the guy appeared in front of a Claremont County judge where he was indicted on 9 counts of aggravated murder. This guy could face the death penalty. He's already confessed to committing the murders, according to prosecutors, and today he pled not guilty. Episode. Hey, welcome to Profiling Evil. Hit that like and subscribe button, folks. Let's dive right in to the Chad Doerman arraignment that occurred today. You've watched this case. You can go back and catch my previous videos if you haven't. But we learned a whole lot more about the elements of this murder case. We now know that Doerman first killed his 4-year-old son. This little boy's name was Hunter, and he shot him twice in the head inside the family's home. It was at that time that 7-year-old Clayton fled the home and was shot from behind by his father as he ran through a field. Doerman then went out to this injured child and shot him in the head. That's the second child. The prosecution then told us today that Doerman ripped the 3-year-old child, Chase, from his mother's arms and put a bullet in the boy's head. That's when the mother got shot in the hand, apparently. Well, in addition to these murder charges, Doerman faces 8 counts of kidnapping and 4 counts of felonious assault. And the prosecutor was pulling no punches when he said, "My goal is to have this man executed for slaughtering these 3 boys." Now, you'll remember in my last video, we talked about how the state attorney general, David Yost, has said he wants to get rid of the death penalty. I sure wonder if they're reconsidering that today. And you know what? This is a death penalty case by all accounts. So unless the state moves really quickly, this guy's going to probably face the death penalty. Well, at the end of the video, I'm going to play a recording from today's hearing. Now, the sound was terrible in the courtroom, so I've tried to clean it up using some special software that I have. But first, I want to go back to last week when he made his first initial hearing and bail hearing so that you can hear the entire thing as the prosecutor started to lay this thing out one day after the murders occurred. Let's listen.
For the court today, for purposes of bond hearing, Mr. Kelm, you were here on behalf of Mr. Doerman. Mr. DeCalvi, Mr. Gass on behalf of the state of Ohio. Mr. Kelm as the bond. Go ahead, sir.
Morning, Judge.
Good morning.
Judge, we've got law enforcement with us here today. Our office has been involved. Lots of people from our office have been involved with law enforcement throughout yesterday, afternoon, evening, all the way through this morning. And the facts I have for you at this point are as follows. The trauma that this man has inflicted on his family, the community, law enforcement, first responders, and all of the rest of us who have any idea what's going on here is unspeakable. There's been a full admission in this case, Judge. The case is still new. We're still discovering facts. But the evil horror of what we know is impossible to process. In an act of just incomprehensible cruelty, the father that stands before you lined up his 3 young boys, and he executed them in his own home with a rifle. They were ages 3, 4, and 7, Judge. In an act of desperation to save her children, the mother at some point grabbed the gun that father was wielding to attempt to protect them. We know that one of the boys was able to flee into a field near the home. And again, we know from his admission, father hunted that boy down, drug him back to the property, and executed him in front of witnesses. The mother was shot through the hand in her attempt to protect her children. Judge, I asked the court in setting this bond to just begin to imagine their fear. This was the man that every day they woke up looking to for protection, love, guidance in all things. Man, they trust more than any other person on earth. Person they rely upon to keep them safe from harm. He was their world. He was their guardian. And he executed them in cold blood. We know that from his admission. By that same admission, Judge, he has committed one of the most monstrous, craven, cowardly acts it will ever be our misfortune to see. To make things even more disturbing, Judge, this was no haphazard act. Again, by his own admission, he planned the events of this day. This did not happen on a whim. He's confessed to what I believe is the worst crime, at least I hope, that I'll see in my lifetime. I hope it's the worst fact pattern that ever comes before this court. Judge, it's important for the court to know, and the bond we're going to request today, for the court to understand Claremont County deputies, Monroe Township Fire and EMS, and other first responders bravely respond to the scene where they don't know what's going on. They did not know what they're facing, and they come into a scene that no one can ever be prepared for. No law enforcement training, no training of any kind prepares you for this. It's easy to forget that these are men and women with families, children, feelings, emotions. They're not some automaton performing a delegated function. They're people. They were required to give CPR to gunshot children, 3, 4, and 7-year-old children. They held these boys in their arms, knowing there was nothing they could do to save them. How long do those scars last? What day do you wake up from that and you're healed? How do you unsee such an abomination? The bond factors this court needs to consider today are set forth in Criminal Rule 46, nature and circumstance of the crime charged, and specifically whether the defendant used or had access to a weapon, including the seriousness of the offense. It's the most serious offense that we have on the books, Judge. This is it. You can't commit a more serious offense. So the nature of the crime charged is the worst crime that can be charged. Did he have access to a weapon? Yes, obviously he did. The weight of the evidence against the defendant at this point, Judge, we stand here with a full admission of the defendant. That also goes to the confirmation of the defendant's identity, and witnesses on scene did see at least part of what happened here. Next, the court is to consider the likelihood this person would return to court if a bond were issued. Again, this is the most heinous crime with the most severe penalty under the law that we presented to the grand jury. That alone would be a major factor in discouraging a person from availing themselves to this court or any other. And the thought to flee and the likelihood of flight is great in the state's opinion. The danger he poses to the community is a factor that this court can consider, and I think with the facts in front of you, Judge, we can't name a person that poses a greater threat to the community. As his prior record goes, Judge, it is fairly minimal. He was charged with a domestic violence in 2010. He is not, to my knowledge, on probation or community control.
Well, these victim children are going to have a memorial service on Sunday at the First Baptist Church of I think it's called Jen Esty, but I'm not exactly sure. Now, they're hopefully going to have video of the proceedings so that people can watch. But for now, let's watch today's arraignment, and I hope, again, you'll put your comments down below. I want to remind you, I tried cleaning up the audio the best I could, so hopefully it's a little bit easier to hear. But let's listen to the hearing today.
We're on the record. All right, the court's going to call 23 CR 0407, State of Ohio versus Chad C. Doerman. Are you Mr. Doerman? Yes, sir. All right, Mr. Myers, Greg Myers is present as well.
Yes.
Mr. Stephen Haynes is present. Mr. Mark DeColby, prosecutor for the county, Ms. Laura Barron Allen, and Mr. Clayton, correct?
Correct.
All right, let's make that a record. Ms. Marcone is the court reporter today, and pursuant to Ohio Rules of Appellate Procedure 9A and B, the court is going to swear you in, Ms. Marcone. You would please raise your right hand. I, Vicky L. Marcone, having been duly appointed as an official court reporter for the Commonwealth Police Court in Mount County, Ohio, do solemnly swear and promise to uphold the Constitution and the laws of the United States of America and the Constitution and laws of the state of Ohio, and to faithfully and partially discharge the official duties of the court of court reporter. Please say that you will. Thank you. Would you please stop? Thank you. So, for the record, for purposes of these proceedings, the court will order that Ms. Marcone will be the official transcriber of these proceedings without any further prior trial court approval. Mr. Haynes and Mr. Myers, you filed a motion to appoint lead counsel, co-counsel. You want to be heard on that before we get into the arraignment?
Yes, Your Honor, thank you. We just submitted it along with an entry Ms. Barron has signed on behalf of the state. You know, we're both certified, I'm certified as co-counsel. Mr. Myers is certified as lead counsel. We've already talked with Mr. Doerman. He is indigent, eligible for public defender representation. We'd ask the court to appoint us if it would be appropriate.
All right.
Thank you, Judge.
Here, so ordered. I've signed that entry. I'll instruct the clerk, and she knows this, to send a notice to the Supreme Court of this indictment. I want to put that on the record. Also, Mr. Haynes and Mr. Myers, there's a form from the Supreme Court. It's called an appointment form of trial counsel. I think the PD or public defender prepares that. Do you know what I'm speaking
Yes,
of?
Your Honor, Mr. Haynes and I will take care of that afterwards on record today.
That's good.
Bring it to your staff, and I think it falls to the court then to forward that to the Ohio Supreme Court.
I think you're right. And then the court will send its own entry to the Supreme Court verifying that the clerk has sent a copy of the indictment to the Supreme Court. So we'll make that record. All right. Does Mr. Doerman have a copy of the indictment?
Yes, Your Honor.
You've already provided that for
Yes,
him?
we went over it with Ms. Fate would have it in the jail last night. Due to certain security restrictions he's facing at this stage, he didn't physically have a copy, but we gave him one. We understand that jail staff also alerted him to the existence of the indictment shortly after it was filed.
All right, as to Mr. Doerman, Mr. Haynes, and Mr. Myers, is he eligible then for public defender?
He is, Your Honor.
All right. The court will sign that entry. Now, relative to arraignment, my preference is, and thank you, Ms. Fairmount, for submitting to the court the possible penalties. I went over it. I think we also, hopefully the defense got a copy of it.
We did.
All right, so what I'd like to do, or my preference would be, Mr. Aaron Allen, like the last couple of cases we've had, I'd love for you to go through each count independently. Put on the record what the state believes the possible penalties are. Then I'm going to turn to Mr. Myers and Mr. Haynes to see if they agree. And then I'm going to ask Mr. Doerman if he understands. And then we'll move to count 2, count 3, count 4, count 5, all the way through. Are you okay to do that?
Your Honor, may I address the court from
Yeah.
the council table?
Yeah.
Thank you, Your Honor. And yes, I could absolutely do that for the court. I wasn't sure since counts 1 through 3 are all charged under 290301A, if you'd like to address them in group.
Individually. Yeah, thank you.
Count 1, aggravated murder pursuant to Ohio Revised Code 290301A. There are multiple aggravating circumstances specifications attached to the underlying charge, including victim under 13 specification, force of conduct specification, felony murder specification, and firearm specification. The possible penalty, if convicted on the underlying charge of aggravated murder, as well as any of the aggravating circumstance specifications, is recommendation of death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification carries with it 3 years mandatory, which must be served prior to and consecutive to any imposed prison sentence. There's also a possible fine of $25,000. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties would be life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years. And again, the firearm specification would carry that 3 years mandatory, which must be served prior and consecutive to any post-prison sentence. Again, same fine.
All right. Does the defense agree with the recitation relative to count 1, Mr. Myers and Mr. Haynes?
We do, Judge.
And Mr. Doerman, do you understand that?
Yes, sir.
All right, ask the count 2, please.
Thank you, Your Honor. Count 2 is also charged pursuant to Ohio Revised Code Section 290301A, aggravated murder, unspecified felony. And again, there are multiple aggravating circumstances specifications attached to that charge. The victim under 13 specification, course of conduct specification, felony murder specification, and a firearm specification. The possible penalties if convicted of the underlying crime of aggravated murder, as well as any of the aggravating circumstance specifications, would be death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification, again, is 3 years mandatory, which must be served prior to and consecutive to any post-prison sentence, and a possible fine of $25,000. If convicted of the underlying aggravated murder charge without any aggravating circumstance specification, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, and life with the possibility of parole after 20 years. Again, the firearm specification is that 3 years mandatory, as well as the $25,000 fine.
Thank you. Mr. Myers and Mr. Haynes?
We agree, Judge.
Okay. And Mr. Doerman, you understand? At the count 3, Ms. Baronell?
Thank you, Your Honor. Count 3 is also charged pursuant to Ohio Revised Code Section 290301A, aggravated murder, unspecified felony. It also carries with it multiple aggravating circumstance specifications, the victim under 13 specification, course of conduct specification, and felony murder specification, as well as that firearm specification. The possible penalties if convicted of the aggravated murder, as well as any of the aggravating circumstance specifications, would be death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. Again, the firearm specification carries with it that 3 years mandatory, must be served prior to and consecutive to any post-prison sentence, and the $25,000 fine is possible. If convicted of the aggravated murder without any aggravating circumstance specification, the possible penalties would be life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years, and again, the firearm specification is 3 years mandatory and same fine.
Thank you. As to count 3, does the defense agree with the possible penalties that have been recited?
Yes, sir. We do.
For the record, Mr. Haynes, Mr. Doerman, you understand?
Yes, sir.
Thank you, Mr. Baronell. And as to count 4, please.
Thank you, Your Honor. Count 4 is charged pursuant to Ohio Revised Code, Section 290301B, again, aggravated murder and unspecified felony. There are multiple aggravating circumstance specifications attached to that count as well. The same aggravating circumstance specifications of victim under 13, course of conduct specification, and felony murder specification, as well as that firearm specification. Again, convicted of aggravated murder, as well as any of the aggravating circumstance specifications, the possible penalties would be death, life without parole, life with the possibility of parole after 30 years, or life with the possibility of parole after 25 years. The firearm specification again carries that 3 years mandatory, which must be served prior and consecutive to any imposed prison sentence, and the possible fine of $25,000. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties would be life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years, and that same firearm specification of 3 years mandatory, and the same fine of $25,000.
Thank you. Mr. Myers or Mr. Haynes?
We agree, Your Honor.
You agree. Mr. Doerman, you understand? Thank you. As to count 5, Ms. Baronell.
Thank you, Your Honor. Again, count 5 is charged pursuant to Ohio Revised Code Section 290301B, aggravated murder and unspecified felony. Also attached are multiple aggravating circumstance specifications, the victim under 13 specification, course of conduct specification, felony murder specification, and firearm specification. If convicted of the underlying crime of aggravated murder, as well as any of the aggravating circumstance specification, the possible penalties would be death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification is 3 years mandatory, possible prison sentence. It must be served prior to and consecutive to any imposed prison sentence. The possible fine of $25,000. If convicted of the aggravated murder charge without any of the aggravating circumstances specifications, the possible penalties would be life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years, and the firearm specification, again, that 3 years mandatory, and the same fine of $25,000.
Thank you. Mr. Myers and Mr. Haynes.
We agree, Your Honor.
Mr. Doerman, you understand? Thank you, Ms. Baronell. And as to count 6, please.
Thank you, Your Honor. Again, count 6 is charged pursuant to Ohio Revised Code, Section 290301B, aggravated murder and unspecified felony. Attached to that count, multiple aggravating circumstance specifications, the victim under 13 specification, course of conduct specification, felony murder specification, as well as a firearm specification. If convicted of the underlying charge of aggravated murder, as well as any of the aggravating circumstance specifications, the possible penalties would be death, life without parole, life with the possibility of parole after 30 years, or life with the possibility of parole after 25 years. The firearm specification carries that 3 years mandatory, which must be served prior and consecutive to any imposed prison sentence. A fine of $25,000 is also possible. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years. Again, that's firearm specification, 3 years mandatory, and that same possible fine of $25,000.
Thank you. Does Mr. Myers and Mr. Haynes, you agree with that?
Yes, Your Honor.
Mr. Doerman, you understand? All right. Thank you, Ms. Baronell. And as to count 7, please.
Thank you, Your Honor. Count 7 is charged pursuant to Ohio Revised Code Section 290301C, aggravated murder, unspecified felony, and multiple aggravating circumstance specifications attached, including victim under 13 specification, the course of conduct specification, felony murder specification, and firearm specification. The possible penalties are possibility of death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification carries with it 3 years mandatory, which must be served prior and consecutive to any prison term, possibility of a fine up to $25,000. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years, and the same firearm specification of 3 years mandatory, and that same possible fine of $25,000.
We agree, Your Honor.
Thank you, Mr. Haynes. Mr. Doerman, do you understand? Thank you, Ms. Baronell. And as to count 8, please.
Thank you, Your Honor. As to count 8, again, that is charged pursuant to Revised Code, Section 290301C, aggravated murder and unspecified felony. There are multiple aggravating circumstance specifications attached to that count as well. The victim under 13 specification, course of conduct specification, felony murder specification, and firearm specification. If convicted of a crime of aggravated murder along with any of that aggravating circumstance specification, the possible penalties would be death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification carries with it 3 years mandatory, which must be served prior consecutive to any imposed prison term, and a fine of up to $25,000. If convicted of aggravated murder without any aggravating circumstance specification, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years. Again, the same firearm specification, 3 years mandatory, and the same possible fine of $25,000.
Thank you. Mr. Myers and Mr. Haynes.
We agree, Your Honor.
Mr. Doerman, you understand? I'm sorry.
Honor.
Thank you. As to count 9, Ms. Barronell.
Again, count 9 similarly is charged pursuant to Ohio Revised Code, section 29.301C, aggravated murder and unclassified felony. Attached are multiple aggravated circumstance specifications, including the victim under 13 specification, of course of conduct specification, felony murder specification, and firearm specification. The possible penalty if convicted of both the aggravated murder and any of the aggravated circumstance specifications would be death, life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years. The firearm specification carries with it 3 years mandatory, which must be served prior to and consecutive to any imposed prison sentence, and a possible fine of $25,000. If convicted of aggravated murder without any of the aggravating circumstances specifications, the possible penalties are life without parole, life with the possibility of parole after 30 years, life with the possibility of parole after 25 years, life with the possibility of parole after 20 years. Again, the firearm specification carries with it that 3 years mandatory and a possible fine of up to $25,000.
Thank you. Mr. Myers and Mr. Haynes.
We agree, Your Honor.
Mr. Doerman, you understand? Thank you, Ms. Barronell. As to count 10, please.
Thank you, Your Honor. Count 10 is charged pursuant to Ohio Revised Code, section 29.050183, as kidnapping, the felony of the first degree. There is also a firearm specification attached to that. There is a presumption for prison attached to that count, and Reagan Chokes would apply in any sentence that is imposed. There's a minimum term of 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. As an example, if 11 years was imposed, the prison sentence would be 11 to 16.5 years pursuant to Reagan Chokes. The firearm specification, again, is a 3 years mandatory, would have to be served prior and consecutive to any imposed prison term, and the fine is a possibility of up to $20,000.
We agree, Your Honor.
Thank you, Mr. Haynes. Mr. Doerman, do you understand that?
I understand, Your Honor.
And thank you, Ms. Barronell. As to count 11, please.
Thank you, Your Honor. Count 11 is charged similarly pursuant to Ohio Revised Code, section 29.050183, that is kidnapping, felony of the first degree. There is a firearm specification. Again, there is a presumption for prison, and Reagan Chokes would apply in sentencing on the count. Carries with it a possible prison sentence of a minimum term of 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, and by way of example, if 11 years is imposed, it would be 11 to 16.5 years. The firearm specification would be 3 years mandatory to be served prior and consecutive to any other imposed prison sentence, and a fine of $20,000.
We agree, Your Honor.
Thank you, Mr. Haynes. Mr. Doerman, you understand? All right. Thank you. As to count 12, please.
Count 12, again, charged pursuant to Ohio Revised Code, section 29.050183, kidnapping, a felony of the first degree, as well as a firearm specification. As to the charge of kidnapping, there is a presumption of prison, and Reagan Chokes will apply at sentencing. The minimum term of prison that is possible will be 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, by way of example, 11 to 16.5 years. The firearm specification will be 3 years mandatory to be served prior and consecutive to any prison term imposed, and a possible fine of $20,000.
Thank you, Mr. Myers and Mr. Haynes.
We agree, Your Honor.
Mr. Doerman, do you understand?
I understand.
Thank you. As to count 13, please.
Count 13, also charged pursuant to Ohio Revised Code Section 290501A3, kidnapping or felony of the first degree, as well as the firearm specification. There's a presumption for prison, convicted of kidnapping, and Brady jokes will apply at sentencing. The minimum term possible would be 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, example, 11 years imposed, it would be 11 to 16.5 years. The firearm specification is 3 years mandatory. Again, must be served prior and consecutive to any other prison sentence imposed, and a fine of $20,000.
Thank you. Mr. Haynes or Mr. Meyer?
We agree.
Mr. Doerman, you understand?
Yes, sir.
Thank you. As to count 14, please.
Count 14 is charged pursuant to Ohio Revised Code Section 290501A2. Again, kidnapping, felony of the first degree, as well as the firearm specification. There's a presumption for prison, and Brady jokes will apply at sentencing. The minimum term possible is 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, by way of example, 11 to 16.5 years. The firearm specification is 3 years mandatory, and a $20,000 fine.
Thank you. Mr. Myers or Mr. Haynes?
We agree.
Mr. Doerman, you understand?
Yes, sir.
Thank you. As to count 15, please.
Count 15 is again charged pursuant to Ohio Revised Code Section 290501A2, kidnapping, a felony of the first degree, as well as the firearm specification. The kidnapping, there's a presumption of prison, and Brady jokes will apply at sentencing. The minimum term possible would be 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, by way of example, if 11 years is imposed, it would be 11 to 16.5 years. The firearm specification is 3 years mandatory, and a $20,000 fine.
Mr. Haynes, thank you. Mr. Doerman, you understand?
Yes, sir.
Thank you. As to count 16, please.
16 is also charged pursuant to Ohio Revised Code Section 290501A2, kidnapping, a felony of the first degree, as well as the firearm specification. Again, there is a presumption for prison, and Brady jokes will apply at sentencing. The minimum term is 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2, which, for example, would be if 11 years are imposed, it would be 11 to 16.5 years. The firearm specification is 3 years mandatory, and a $20,000.
Thank you. Mr. Haynes?
We agree, Your Honor.
Thank you. Mr. Doerman, you understand?
Yes, sir.
As to count 17, please.
Count 17 is also charged pursuant to Ohio Revised Code Section 290501A2, kidnapping, felony of the first degree with a firearm specification. Again, there is a presumption for prison, and Brady jokes will apply at sentencing. The minimum term is 3, 4, 5, 6, 7, 8, 9, 10, or 11 years, up to the minimum term imposed plus 1/2. Again, by way of example, if 11 years would be imposed, the prison sentence would be 11 to 16.5 years. The firearm specification is 3 years mandatory, and the possible fine is $20,000.
Thank you, Mr. Haynes.
We agree.
Mr. Doerman, you understand?
Yes, sir.
Thank you, Ms. Mary Allen. As to count 18,
Thank you, Your Honor. Count 18 is charged pursuant to Ohio Revised Code Section 290311A2. It is felonious assault, a felony of the second degree, and there is a firearm specification attached to that. Again, there is a presumption for prison, if convicted, and Brady jokes will apply at sentencing. The minimum term possible will be 2, 3, 4, 5, 6, 7, or 8 years, up to the minimum term imposed plus 1/2. Again, by way of example, if 8 years would be imposed, the sentence would be 8 to 12 years. The firearm specification is that 3 years mandatory, which must be served prior and consecutive to any other prison sentence imposed, and the possible fine is $15,000.
thank you, Mr. Haynes.
We agree, Judge.
All right, Mr. Doerman, you understand?
Yes, sir.
Thank you. As to count 19, please.
Count 19 is charged pursuant to Ohio Revised Code Section 290311A1. That is also felonious assault, felony of the second degree with a firearm specification. Again, there is a presumption for prison, and Brady jokes applies. The minimum term would be 2, 3, 4, 5, 6, 7, or 8 years, up to the minimum term imposed plus 1/2. Again, by way of example, if 8 years was imposed, the prison term would be 8 to 12 years. The firearm specification is that 3 years mandatory, and the fine is $15,000.
Thank you, Mr. Haynes.
We agree, Judge.
Mr. Doerman, you understand?
Yes, sir.
Thank you. As to count 20, please.
Count 20 is charged pursuant to Ohio Revised Code Section 290311A2, and felonious assault, that is a felony of the second degree, and there is a firearm specification attached to that count as well. There is a presumption for prison, and Brady jokes will apply at sentencing. The minimum term is 2, 3, 4, 5, 6, 7, or 8 years, up to the minimum term imposed plus 1/2. And by way of example, if 8 years is imposed on that count, the prison term would be 8 to 12 years. The fine specification is 3 years mandatory and the fine $15,000.
Thank you, Mr. Haynes.
Ready, Your Honor.
Mr. Doerman? Yes, all right. Thank you. As to count 21.
Thank you, Your Honor. And as to count 21, that counts charged pursuant to Ohio Revised Code Section 2903-11A1 felonious assault. The felony of the second degree, there is a firearm specification attached to that count as well. Again, there is a presumption for prison and breaking those would apply to sentencing. The minimum term would be 2, 3, 4, 5, 6, 7, or 8 years, up to the minimum term imposed plus 1/2. And by way of example, if 8 years was imposed, the prison term would be 8 to 12 years. The firearm specification is at 3 years mandatory and the fine possible up to $15,000.
Thank you, Mr. Haynes.
We agree, Your Honor.
Mr. Doerman, you understand? All right, I think that covers the entirety of the indictment.
It does, Your Honor.
All right. At this time, Mr. Myers and Mr. Haynes, based upon the recitation of the indictment and all the possible charges and possible sentences, what is the plea of your client at this time?
Plea is not guilty, Your Honor.
All right.
We reserve the right to file later pleas.
Absolutely.
Thank you.
Because of the nature of,
The judge should say, I think Mr. Myers touched on it, but it hasn't been quite 24 hours since he was indicted or read the indictment, so he's going to waive the 24-hour waiting period.
okay, thank you. Would you please, Mr. Haynes, step up, and then if you and Mr. Myers could sign as attorneys for Mr. Doerman, and then have Mr. Doerman sign.
We're excited, Judge.
Thank you. So for the record, Mr. Haynes, you signed, Mr. Myers signed, correct?
Correct, Your Honor.
All right. And Mr. Doerman, you signed as well. All right. As the bond stated, is that called?
Yes, Your Honor. I'll be discussing bond. Your Honor, as the court is aware, pursuant to Article 1, Section 9 of the Ohio Constitution, this,
Judge, we're not going to object to bond.
We pass on.
Meaning that if he's asking for, they're going to ask for a no bond.
correct.
And
Here's where it gets graphic, guys. So, just so you're aware, I just wanted you to know.
We're not opposing.
are you comfortable with that?
The Constitution says where proof is evident and.
Continue. Go on, continue.
Judge, I think.
Make a record.
Thank you, Your Honor. The court needs to have some understanding of the facts. What we have here is the planned slaughter of 3 little boys, ages 7, 4, and 3. The first one shot was the 4-year-old, shot in the house 2 times and sustained 2 bullet wounds to the head, causing his death. The second child shot was a 7-year-old who fled the residence, ran some 300 feet from the residence, and was gunned down from behind by the defendant. He then approached this little boy who was injured, incapacitated, alive, shot him in the head twice from close distance. There were powder burns in the boy's head. Then he went after the 3-year-old. There was a struggle with the mother. He ripped the child from the mother's arms and put a bullet in his head. Close range, powder burns on the 3-year-old boy's head. Your Honor, those facts are important for the court to know in terms of this being a capital case. We find, Your Honor, my conclusion is that proof is evident and the presumption is great. May he be held without bail.
All right. Thank you. Defense has nothing to add.
Yeah, you're right.
All right, the court's going to order based upon Article 1 of the Ohio Constitution, Section 9, that's been amended on November 8th, 2022. The bond in this case be no bail at the present time. And what the court's going to do is prepare an entry that contemplates that, because my normal judgment entries do not contemplate Article 1, Section 9. So we'll put one together indicating the court's order of no bail. Anything from the defense at this time? Anything else before the court notes that the case is assigned to Judge Ferentz, and the court date, we want to work around schedules. Do we have a date?
Originally, it was set for July 5th. Is there another day?
Is that a bad day?
It's up to the attorney.
Can everyone do July 5th?
I can do that, Judge.
Yes,
Yes, yes, Your Honor.
Okay, Mr. Myers?
The fifth would work. I might indicate, as I'm now reminded by co-counsel Mr. Haynes, we're before this court the following day on Mr. B.O.L.'s case, and I would wonder if,
At 10:30.
I mean, obviously I'll work with both court schedules.
Well, we want to work with your schedule, but I think the heightened security is a little too much for us to have both of them
Oh, I see.
at the same time, because they're both death penalty cases.
So
But I know you come a long way, but.
that's all right. Part of the job.
All right.
So we'll be down here on the 5th for a pre-trial then?
Yes,
Okay.
and we're looking at a time,
Right.
because I'm trying not to insert it on his regular docket, so that Judge Ferentz has some time.
Gotcha.
It could be 10 o'clock, 11 o'clock, or 1 o'clock.
About 11. Is that all right with everybody?
Does that work for everyone?
Fine.
Okay, 11 o'clock. For the court's own edification, Mr. Doerman, can you please tell me how old you are?
32.
And what's your date of birth?
3191.
Does that work for everyone?
Fine.
Okay, 11 o'clock. For the court's own edification, Mr. Doerman, can you please tell me how old you are?
32.
And what's your date of birth?
3191.
And are you a citizen of the United States?
Yes.
All right. At this point then, Mr. Haynes or Mr. Myers, is there anything else that you want the court to consider?
You know, I think just on the technical front, we would waive the reading of the indictment. We discussed that
Thank
with
you.
Mr. Doerman at length yesterday.
Thank you. Would the defense have any issue, I'm just asking, waiving time till the next hearing?
No, Your Honor.
All right. Terry, can you tell me that date again, please?
July 5th at 11 a.m.
And we're gonna call it a pre-trial. And then, Mr. Myers and Mr. Haynes, would you please sign as attorneys for the defendant? Have Mr. Doerman sign, and then have one or all three of the prosecutors sign. Bless you. Okay. Thank you, Mr. Haynes. For the record, Mr. Haynes, you signed the time waiver.
We did, Mr. Doerman did, Mr. Myers did, Judge. Yes.
Mr. Doerman, you signed it.
Yes.
Mr. Prosecutor.
I did, Judge.
The court signed it. Also, the court received, for the record, the appointment of trial counsel on the capital case. Here it is. Mr. Haynes and Mr. Myers, I need both of you, one to side as lead, and one as co-counsel, if you would, so we can get that to the Supreme Court. Let me make sure.
Your Honor, may I have a question?
Yeah, I don't know that I'm gonna be the trial judge on this. It's gonna be such fast. I think you need to put Judge Ferris.
It came from Greg Myers.
I was doing that as we were hearing all the penalties. And I wasn't, frankly, I wasn't sure if it should be the appointing judge, or I think you're probably right, it should be the assigned judge.
I would think,
So,
or both, but I think you need to be on there because, the only issue is because your signatures, I don't know if these are signatures or if we can just put your name. I think we have to sign. You do have to sign. So can you redo that?
I can't.
Just change. I don't know Judge Ferris's registration number.
I can find all that when we're on the record, Judge. It takes a little bit of doing.
No, that's fine. I'm gonna put that to the side, so we'll be on you to try to get that. Let's see if I have anything else on my list. Anything else, defense? Anything the state can think of?
No.
Any questions, Mr. Doerman?
No.
All right, court's in recess for this purpose.
Thank you.
All right.
Judge, I'm gonna fill out another one of those
Thank you.
forms, and then I'll.
Yeah, take your time. Yeah, that's great. But we still need your signatures on.
Yeah.
Well, there you go, folks. This one's a tough one, and I hope you'll be kind to each other as you look through each other's comments. This one was a tough one, and it came at a really difficult weekend. Boy, I'm looking forward to reading your comments. I hope you'll check out Profiling Evil on Facebook, YouTube, Instagram, and Twitter. Make sure you're getting our podcasts. Thanks for your support of Profiling Evil, and we'll see you soon at the next crime scene.